I just pressed the let's go live button, so let's wait for the stream to fire up on this beautiful Friday. We are early here, and that's because we've got a lot to attend to. We've got some serious fresh stories that just came out of the oven, and we cannot wait to get to them. So let's do it as soon as the stream is confirmed that we're working, we're alive and well. It looks like it's good. So let's get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney broadcasting from the Valley of the Sun, deep in downtown Phoenix, Arizona. And it's a beautiful Friday, and we have a ton to get to, a bunch of stories just kind of batched up at the end of the week. We spend a lot of time talking about Trump and Proud Boys, but there is a lot of other business out there percolating, including removal, which is the word of the day. We have a new filing in the Trump case. He is being prosecuted by Alvin Bragg, and he is filing a motion or a notice of removal. And I know it's a big scary word when we talk about the language with Trump removal. It's like, man, they've been working on that for a long time. But Trump is filing this. He is asking the court to take it out of the New York City's court and move it up into the federal courts. And so his team filed a 9-page motion. I want to read through it. I want to go to this article, talk about the consequences of the removal. Reason.com put together a very nice technical analysis of how this works, which we can get up to speed on. And then, of course, the Justice Department is intensifying their efforts to go and investigate Donald Trump and really dig into that hidden documents ordeal. And as we speculated yesterday, we think that the end game here is to ultimately prosecute Trump. So we'll talk about that. Then I want to turn our attention to some state news. We had a new order come out in the Kari Lake case. The case is now being sent back to the lower level Superior Court. Things were kind of in a stall for a while. We were waiting for some activity, waiting to see what was going to be happening here. The Supreme Court came out with an order, then they sent it back down to the Superior Court. And so remember that Kari Lake won on the one appeal, the one issue, which was about signature verification. And so now the process is going to restart again, and we're going to come back down, and Kari Lake and her team, we should start seeing some activity again soon. Then we got some interesting and very welcome news. Kim Gardner decided to resign, and this is a little bit of a change of pace for her, because earlier this week, we heard from her when she was giving one of her press conferences. She said, "I'm not going anywhere. They're going to have to come and take me out." Well, she submitted her letter of resignation yesterday, and so we'll read through all of that. We had there a clip from the judge, and we had the McCloskeys. You remember the McCloskeys back from the Summer of Love when they were standing out on their front porch with their weapons? And they got arrested and charged for defending their home. Well, you can see he's having a nice little cheers. So if you want to also join him in the cheers, get your champagne ready on the Friday. Now, we also have an interesting update in this Manifesto ordeal. Remember, this situation out of Nashville happened a long time ago. They promised us we were going to learn a little bit more about it, what happened here, because there was a bunch of materials that they gobbled up as part of seized property. And there were journals, there were notepads, there was a note that a person leaves before they leave. There were passwords, there were Macs, there were all sorts of stuff, things that we wanted to see here. And so they have not been releasing the manifesto or anything. And now a National Police Association has filed a lawsuit to get it. And so we'll take a look at what that lawsuit has in store for us as well. Pretty shocking news came out from the CIA. We've covered this here. It continues to boggle my mind that these people were so openly corrupt about this. But Michael Morrell, the former CIA director, who was one of the signatories to the 51 so-called intelligence idiots who drafted that Hunter Biden laptop cover-up letter. Well, there's a new email that he sent to John Brennan, and they talk about literally creating and concocting this whole scheme so that they can give Joe Biden a talking point. And I've got the email, which we will read through here very shortly. Now, there's another update on Biden. He has been questioned, or Congress is questioning the DOJ and the FBI about his potential involvement in criminality. And got several clips on that one. Chuck Grassley is saying the DOJ must come clean on this. They're essentially wrecking their institution. James Comer says he really believes this whistleblower who came forward saying that the document unveils the truth about what the Bidens have been up to is legitimate and accurate, and we'll see what the White House has to say about it, if anything. And then lastly, Congress is going pretty hard at the DOJ. We saw that they demanded a document. They actually sent over a subpoena to the FBI, and now they're demanding access to this guy, U.S. Attorney Matthew Graves. Somebody's been very involved in the domestic terrorism efforts over there at the DOJ and investigating all the J6 cases and hyperventilating about that stuff for years. So the House of Representatives, the Oversight Committee, they sent in a letter over to the DOJ basically saying, hey, you have the opportunity to voluntarily come and work with us. Otherwise, we're going to make this process compulsory. And that's very likely going to happen. So the battle between the branches of our government continues, and we're looking forward to seeing what Congress can do as it heats up. And so, my friends, look at all of this stuff. Woo! We've got a lot to get to. And if you want to be a part of the show, well, the best place to do that is by going over to Watching the Watchers. What the heck is Jigam doing up there? Oh my goodness, look, Jigam got moved. We got to move her back. If you want to use this mind map stuff, it's very easy. You see how I move that? You can do that. You can go over to spotlightlawyer.com/mindmap, and this stuff is very, very fun. Sometimes I get a little bit trigger happy with the keyboard, but we got everything nice and orderly again. However, if you want to be a part of our community where Jigam is, then come and join us at watchingthewatchers.locals.com. She says, I can fly. And so watchingthewatchers.locals.com is our amazing community. And if you join us on YouTube, don't forget to grab the Telegram link, because that's where our after party is. And we'll see you after the show over there. Now, as you saw, there's a lot that we got to get into. And so, we got to be properly nutrified and fortified. Our food quality's mostly garbage these days. So that's why we need to focus on Field of Greens, so we can lose some of those leftover pandemic pounds. And we're all sick of all the ads for the weight loss pills and the fad diets. We've all been there. We've all done it. We've all tried it. They just don't work. But you know what does? Eating healthy, especially 5 healthy servings of fruits and vegetables every day. You do that, you imagine the weight would probably just fall right off. But look, I know vegetables and fruit, not a fan. It takes a lot of time to prepare it. Instead, you just take your Field of Greens. It's a science-backed formula, specific fruits and vegetables you won't find in any other product. And we know that proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise that's going to help you look and feel healthier fast. But the greater proof is going to come at your next checkup, when your doctor says, wow, you've lost weight. Whatever you're doing, keep it up. So let's get you started. Go on over to fieldofgreens.com. They've got a ton of stuff. If greens isn't your thing, they've got lean stuff. They've got collagen stuff. They have sleep stuff, fitness stuff. Everything is over there. Fieldofgreens.com. And don't forget to use code Robert so you can save at checkout. And remember, the vegetables want to be eaten. You'll be bursting with green energy, the good kind, courtesy of our friends at fieldofgreens.com. All right, and so let's get right into it today, my friends, because there's a lot. Donald Trump and his team file a motion and a notice for removal. Currently, Donald Trump is being prosecuted out of the district attorney's office out of New York. And Trump is saying, we don't like this jurisdiction. We think this case should be removed from state court up into federal court. And there's some pretty good reasons why they might want to do that, even though removing from a Manhattan type court to a Southern District of New York court keeps it in New York. There are some other benefits to being in federal court versus state court. So we're going to go through the motion and get up to speed on some of the other Trump prosecutions. But here is what Donald Trump and his team filed out of the Southern District of New York. So Alvin Bragg is prosecuting Trump in a state court. Trump filed this in federal court. The case is New York prosecutors versus Trump. And he's filing this in a different court with a different judge. They say this is our notice of removal. We are removing this from the New York Supreme Court, which is not really the Supreme Court. They kind of reverse them. It's actually the lower level court. They say, dear Southern District of New York, President Trump, through counsel, hereby removes this case from the Supreme Court of New York, the state court, up into the federal court, U. They say that this is a pending case that's coming out of New York, County of New York. And as explained below, this court, the federal court, has original subject matter jurisdiction over this criminal action because the case involves important federal questions since the indictment charges Trump for conduct committed while he was president of the United States. That was within his color of office. And the charges involve alleged federal and state election law violations that have a federal preemption defense. Whew! So good stuff here. So they're saying Trump might have some overlap here with these charges and essentially some immunity, right? Some protections. And the federal court, because of the nature of the context around which Trump was, the conduct is alleged to have occurred when Trump was president. Therefore, it's a federal issue. And so they're wanting to remove it up. They say this case also is unprecedented in our nation's history. Never before has a local elected prosecutor criminally prosecuted a defendant either for conduct that occurred entirely while the defendant was sitting as president or for conduct that related to federal campaign laws. And we know that the feds didn't prosecute him for any of those things. So why is the state? They say the notice of removal is timely. They say, dear court, we have done this within the rules. The rules say we have to file this notice within 30 days. We've done that. They say venue is proper because the Southern District of New York encompasses New York County. And remember, we have the federal supremacy clause, and we have the idea, we have dual systems of government, federalism, but also that the feds reign supreme. And because this SDNY jurisdiction encompasses the lower level court, it's not a problem. It's the same jurisdiction. We're just moving it from the state to the feds. The background. The allegations against Trump in this case are based on checks allegedly written to Michael Cohen by Trump in 2017 while he was president. The DA's office alleged that these checks, which Trump allegedly signed while sitting in the Oval Office, as well as related records, are false because they're characterized as legal expenses and retainer payments when they were really made for campaign purposes. Trump's defense denies that they were false records. Now, after investigating this case for 5 years, Trump's team says, in March, a grand jury returned a 34-count indictment against the president. All 34 counts charge the same offense, falsifying business records. And we've covered this at length here, and we remember that there were basically 3 charges, just one right after the other. So what would happen is Michael Cohen would send Trump's team an invoice, felony 1. Trump's team would record the invoice in their bookkeeping records, felony 2. Trump's team would cut a check to pay for the invoice, felony 3. Multiply that times every month, and you get up to 34. There were some months there were double payments and triple payments and other things. That's it. It's like every time you got a bill for your Netflix and logged it and paid it on recurring, felony, 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 felony. The misdemeanor falsifying records is contained in New York law, is relevant here. It punishes a misdemeanor. Under New York law, a misdemeanor is elevated to a felony when they commit the crime, when the intent of the commission of the crime includes an intent to commit another crime, right? And I think what they're alleging here is it's a campaign violation. The DA's office alleges that the crime that Trump intended to commit or to conceal was in connection with the 2016 election. Trump's team says this is a novel theory, that Trump committed a felony under New York law because payments to Cohen were supposedly mischaracterized, and that was done in order to conceal an election crime. There has never, they say, never been a prosecution under New York law based on an election law pertaining to a federal election. And these are serious, and there are serious preemption issues with the prosecution, meaning the feds preempt the state because it's a federal election. The federal election is the feds' purview. And they're saying Trump was involved in concealment for a federal election. He wasn't running for Alvin Bragg's office. He wasn't running for mayor or for governor. He was running for the president. So New York is going to now be enforcing a crime related to the federal crime. The feds aren't investigating that crime, or they have investigated it and decided not to charge. So they're saying, okay, by Alan Bragg's own acknowledgement, he is confirming this pertains to a federal election. So federal court, your business, not theirs. Indeed, as noted by the judge in a recent decision, this is the following legal theory underlying the case. The facts surrounding the payments did not amount to much in legal terms, as paying hush money is not a crime under the law, even if the payment was made to help a candidate. This judge said there appeared to be no felony state crime in play. The Trump investigation should have been handled by the DOJ, not the DA's office. And federal prosecutors previously looked into Clifford storming and the hush money payment, and they did not move forward with the prosecution. Okay, in other words, the feds already looked at all of these things and decided no. Judge Visikill also recognized that Bragg faced political pressure, tons of it, writing that Bragg is an elected prosecutor with constituents, and they want to see Bragg wield a force of law against Trump. So Trump's team says, therefore, Your Honor, removal is required. Under federal law, if we apply, the case must be removed. The removal statute applies to former officers of the United States if they're charged with conduct related to while they were being in office. They raise the different steps. They say Trump has to prove two things in order to get it removed. He satisfies both of these. First, that the federal defense must be colorable and that it was related to in office and it's in connection to the federal office. So he's got a defense under federal law and the conduct pertained to federal office time. Trump satisfies both of these elements. They say, here are some of the defenses Trump's going to raise. President Trump will assert that the statements in the business records at issue were truthful statements. Yeah, we got the invoice, we logged them, and we paid them because the money we paid to Cohen was in part retainer. They were legal payments. Michael Cohen was acting as Trump's personal attorney. At the time of his election, there were some public expressions of concern about conflicts of interest, corruption, and other constitutional violations due to Trump's wealth and business interests. Therefore, shortly before assuming the office of the presidency, and in order to ensure that the American public, to assure them that he had separated business from public, Trump placed his businesses in a trust. And Trump hired Michael Cohen to handle his personal affairs. These steps were taken solely because he was president. And as such, it was Trump's decision to retain Michael Cohen to act as his lawyer, and his decision to do that arose out of his duties as president, right? If Trump wouldn't have become president, he wouldn't have done these things. Therefore, his defense is going to be based around the federal law, him elevating and becoming the president. They say, moreover, Alvin Bragg's office has made clear in court filings that the felony charge was predicated on intent to violate New York election law and federal election law. President Trump will raise a federal defense called preemption to both of these predicate charges. They say here, President Trump, who has only been a candidate for federal office, if you apply the state law to him, that's going to violate U.S. law, which says federal elections supersede and preempt any provision of state law. So Alvin is saying, we're coming after Trump under New York election law 17-152. And Trump didn't run for New York office, weirdo. And if you look over to federal law under U.S. Code section 30143, it says that federal law preempts state law. So the preemption provision preempts the state prosecutor from charging a crime where the element of that crime is a federal campaign violation. Alvin's trying to tuck in a federal violation under state law in order to take that state law and tuck that under the section of state law that allows him to charge him within the statute of limitations. But they're saying you can't do that. The element that you're claiming was violated belongs to the federal statute, and federal prosecutors investigated it, declined to bring the charges, and so you can't bootstrap your charge off of another federal claim and hold the whole thing in state court. It belongs in federal court. They say that in determining whether the underlying conduct relates to acts performed under the color of office and within the meaning of the federal removal statute, we got to show that there's a nexus, some sort of a causal connection between the charged conduct and the official authority. Trump satisfies this. All of the indictments in Alvin Bragg's indictment relate to a claim that Trump falsified his records, saying that these legal expenses were in fact reimbursements paid to Cohen to cover up campaign contributions. As previously discussed, President Trump is going to demonstrate in his defense that Mr. Cohen was in fact his personal lawyer who was only hired as a direct result of Trump becoming president and his other obligations under the Constitution. And acts taken as part of the election to the office of the president relate to the conduct. Therefore, satisfying the standard, there is a nexus here, saying, Your Honor, you can remove this case now because the conduct of paying Cohen to wrap up these affairs was in contemplation of moving into the White House. That's the nexus. Satisfied. Also says, finally, Your Honor, this court has protective jurisdiction. Because this instant indictment is politically motivated and was brought by a local politician here, Alvin Bragg, and it disfavored Trump's acts and policies as president, the federal courts also have what they call protective jurisdiction over this case. Although the Supreme Court has never really decided exactly what that means when federal protective jurisdiction in cases of state hostility come into play, it has been brought up. And so for this reason, they're saying the federal system is under attack by state prosecutors. This is harassment. It could take the process and take the form of unjustified prosecutions. And this court should now step in and claim that is not appropriate and take the case. For this reason, this case is removable, they say, and remove this to federal court. Filed on May 4th, 9 pages in a new civil filing out of the Southern District of New York, document number 1. And we'll be looking forward to seeing what Alvin Bragg says and whether the DOJ gets involved or who else jumps into this mess. But it is good news that they are exercising some authority here and demanding to pull this up. And there's a good explanation as to some of the benefits of doing this. This came over from Reason.com, courtesy of the Volokh conspiracy. Josh Blackman wrote this, and it's a great article if you want to read and get into the nitty-gritty of the U.S. code, the U.S. law, about how all this works. He says, fast forwarding through that, there's a good argument that was brought forward by somebody called David Ripken and Kristen Shapiro. They say Trump should remove the case. They were the people who initially brought this up. Why? Because it might bring to Trump supremacy clause immunity. That comes from a case called McCulloch versus Maryland. It holds that states cannot prosecute a federal officer for engaging in a federal function. Case arose from a criminal prosecution. Trump, they say, doesn't hold a federal position now, but he would still be entitled to that immunity. Saying it should extend to state criminal prosecution of federal officers undertaken because of their federal service, even if the charged conduct is unrelated to their federal duties. Wow, so that's a pretty interesting concept. And if this works its way up to the Supreme Court, we know there's precedent now. As the Supreme Court warned in a previous case, unfriendly states could administer the law in such a manner to paralyze the operations of government. That threat exists anytime a former or current federal officers are targeted for criminal prosecutions because of their service. A president or other official cannot lead effectively under the constant threat of retaliatory prosecution. Mr. Trump has a strong argument here. Does anyone believe he'd be prosecuted for anything with Stormy if he hadn't become president? No, of course not. So now we've got a nice framework upon which the Supreme Court can rule on this and say, no, there is actual precedent here. It's called the Supremacy Clause, and you're immune from this according to prior case law. And Trump is in the middle of this, trying to remove this case to federal court. Now, we know what it's like to be in federal court because Trump currently has another pending case out of the Southern District of New York, which is the E. Jean Carroll lawsuit, which we've been covering at length here, but it's currently on hiatus for the weekend. That court has not been very favorable to Donald Trump. The Southern District of New York is the same jurisdiction that they're applying to here. So if they get Judge Kaplan again, it may not be much of a benefit tactically. Remember, it's going to be the same jury panel, the same jury pool, the same demographics, same mostly Democrats. And that doesn't necessarily put Trump in a better position. But Supremacy Clause immunity certainly does. And we'll see what else he can dig into to invoke immunity against criminal charges, because more criminal charges are certainly coming. Let me log in here. I thought I was logged in. So embarrassing. All right, here we're back. Justice Department intensifying efforts to determine if Trump hid the documents. They're investigating Trump's handling of classified materials. They issued a wave of new subpoenas, and they obtained the confidential cooperation of a witness who worked at Mar-a-Lago. They tell us that federal prosecutors who are investigating Trump have obtained the confidential cooperation of a person who worked with him, part of an intensifying effort. A wave of new subpoenas has gone out. Grand jury testimony has been presented. The Justice Department, according to the New York Times, is now moving aggressively to develop a fuller picture of how the documents Trump took left, how the security camera system works, what Trump told aides and his lawyers. At the heart of the inquiry is whether Mr. Trump sought to hide the documents after the Justice Department issued a subpoena. The existence of an insider witness, whoever this is going to be, whose identity has not been disclosed, could be a significant step in the investigation. They'll have somebody come out and say, he told me to move him. The witness is said to have provided investigators with a picture of the storage room where the material had been held. Little else is known about what the prosecutors might have learned, but prosecutors appear to be trying to fill in some of the gaps in their knowledge about the movement of the boxes. Prosecutors believe that this person, Mr. Nuada, has failed to provide them with a full account of his role in moving the documents. Wow, and they've got 3D renderings here. Man, they're like really excited about this because this is the end game. They've been working on this for a long time. Prosecutors have also issued several subpoenas to Trump's company, seeking additional surveillance footage. Footage could shed light on the boxes. They recently subpoenaed somebody called Matthew Calamari, the longtime head of security who became its chief operating officer. They also investigated his son, Matthew Calamari, who's on the board. Subpoenas going out everywhere. One of the previously unreported subpoenas to the Trump Organization pertained to his Saudi Gulf ventures. Spokesperson for Trump called the case a targeted, politically motivated witch hunt. And they are going in hard. They went after Trump's attorney. He already spoke with the special counsel. They breached attorney-client privilege. The judge said that doesn't apply. So the special counsel's office brought Trump's lawyer in, and he testified, this is amazing that all of this stuff, look at how long this article is. This is supposed to be secretive and sealed. The DOJ is leaking this, just like a sieve, over to the Washington Post, in this case to the New York Times. They got full details. Do they have a journalist, reporter, idiot sitting in there? During his appearance before the grand jury, Mr. Corcoran testified that, were they there? That several Trump employees had told him that Mar-a-Lago room was the only place where the documents were kept, but that was wrong. Although Corcoran testified that he did not personally convey the false information, his testimony hardly absolved the former president. They have multiple people in the investigation. They say there's a wealth of testimony. After months of requests, they finally got the documents, and Corcoran was talking to them. So they will be coming hard after Trump, more so than they already are. And the battle will continue. Of course, we will continue to cover it. Thank you for joining us as we continue to follow Trump along. We'll look forward to seeing you on the next one. Now, let's turn our attention over to some state court issues here, because there is a lot going on here. Kari Lake's case moved forward. Kari Lake's case moves forward. It was stalled a little bit in the Arizona Supreme Court, but we got a new order that's going to be sending it back down to the Superior Court for further proceedings. We have some background from Just the News, which had the opinion. Here's what they tell us. They say that on Thursday, the Arizona Supreme Court ordered court proceedings to take place soon. Kari Lake was the Arizona gubernatorial nominee. She lost by just 17,000 votes. She's suing Katie Hobbs. The case was reviewed by the Arizona Supreme Court in March, and if you remember, we covered this opinion. It remanded one of her 7 counts back down to the trial court. So this was housed up at the Arizona Supreme Court. We were waiting on some rulings, and now we got it. This remanded the count back down, and the one count was about signature verifications. And so with that background, let's take a look at the actual order that came out from the Supreme Court. Here's what it says. In their responses to the petition that came from Lake to review the records, the court is entering, or had already entered, its order affirming the Court of Appeals on most issues, meaning Kari Lake loses most things, but then reversing those courts on their dismissal of the signature verification claim and remanding that issue back down to the trial court. So we were then sort of in this pause moment. Now, the court says, on the issue of whether votes were improperly added by a third-party vendor, Runbeck, or another entity that was shoving ballots in somewhere here in Arizona, we stated that the record does not reflect that the unaccounted ballots were added to the count total, these 35,000 ballots. We instructed the parties to address as the basis for sanctions only Kari Lake's factual claims in her petition for review. The parties filed briefs, Lake filed a motion, and here we are. The court says candidates are free to timely challenge election procedures and the results, and the public has a strong interest in ensuring the integrity of the elections, of course. Sometimes campaigns and their attendant hyperbole spill over into these legal challenges, but once a contest enters the courts, the rules of attorney ethics apply. And although we must ensure that legal sanctions are never wielded against candidates or their attorneys acting in good faith, we also must diligently enforce the rules of ethics on which public confidence in our system depends. Says the Arizona rules authorize a court of appeals to impose sanctions on an attorney in certain cases, in particular when there are frivolous filings. Other rules apply as well. They say that other claims are sanctionable if they are brought without substantial justification. Remember that Katie Hobbs and the Arizona team, they're asking for sanctions against Kari Lake. They want her penalized and punished. They don't want her to ever bring a challenge or anybody to ever challenge him ever again. And so the court is giving us some background on what the rules say in regards to sanctions. It says the rules does give the appellate court broad authority to impose sanctions that are appropriate under the circumstances. And now we apply it to Miss Lake. In her complaint, Kari Lake set forth colorable claims, including ballot chain of custody claims that were rejected following an evidentiary hearing in trial court, which we covered at length here. And she duly, but unsuccessfully, except for the signature issue, challenged those rulings on appeal. However, Kari Lake has repeatedly asserted that it is an undisputed fact, undisputed in quotes, that 35,000 ballots were added or injected at Runbeck, the third-party vendor. Not only is that allegation strongly disputed by the other parties, but this court concluded and expressly stated it wasn't supported by the record, and nothing in Lake's motion for leave revisits that issue. Thus, asserting that it is undisputed is false, but Lake continues to make the argument. The court says Lake's petition for review stated that it was undisputed that they were added. And in her opposition, Kari Lake filed a response, "Don't sanction me. My claims were valid." She repeats this contention. She said it again in her motion defending herself. She said the record indisputably reflects at least 35,000 election day early ballots for which there is no record of delivery to Runbeck were added at Runbeck. Kari Lake says, "I'm doubling down on it." As the Court of Appeals observed, Lake's argument was focused only on one exhibit that included an estimate of the number of early ballot packets based on the number of trays in the different exhibits showing a precise count. Although Lake may have permissibly argued that an inference could be made that some ballots were added, there is no evidence that 35,563 ballots were. And more to the point, this was certainly disputed by the respondents. The representation that this was undisputed, accordingly, is therefore unequivocally false. And therefore, because Lake's attorney made false factual statements to the court, we conclude that the extraordinary remedy of a sanction is appropriate against Kari Lake. Governor and the secretary seek sanctions for attorney's fees, and the secretary wants additional sanctions. All because they said undisputed. Because Lake prevailed in her argument that the trial court improperly found her signature verification argument was barred by laches, an additional sanction is not warranted, however. Therefore, it is ordered denying the motion for leave. It is further ordered denying Secretary Hobbs's motion to strike, and it is further ordered granting the motion for sanctions for stating that it was undisputed. That's unethical. And for repeating the false assertions in the additional filings. And therefore, counsel for Kari Lake is directed to pay the Supreme Court $2,000 as a sanction for this conduct, illegal, unethical words. Such payment to be made not later than 10 days from the date of this order. It is further ordered that failure to pay timely and to comply with this order may result in the termination of the pro hoc vice status, which means you can't practice here in Arizona, and other sanctions as appropriate. It is ordered denying the request for attorney's fees, which is good. And it's further ordered that the trial court shall be forthwith, here you go, the lower level superior court shall forthwith conduct such proceedings as appropriate to resolve the unrelated question previously remanded, directing the clerk of the court to enter the mandate and send it back down to the superior court to get this case back on track. So it's, it's a sanction. It's $2,000. That sucks. And it's a ruling, undisputed. Okay, it was disputed. They put undisputed again, or they re-litigated it in their secondary filing and their opposition. I think they dodged a bigger sanction just simply because of the fact that they won the signature verification count. You can see in this language here, they wanted much bigger sanctions. And Kari Lake's attorney's fee, $2,000 relative to Katie Hobbs's attorney's fees, is nothing. If the judge would have said that he had to pay attorney's fees as well, for Kari Lake to pay the attorney's fees for this whole challenge, it would have been hundreds of thousands of dollars versus $2,000. Okay. Now, if they would have lost all of the counts, right here, they say they want additional sanctions for even bringing this case. The judge says, probably could, but Kari Lake won one of those counts. So I really can't hit her for all of the additional penalties. So good news, actually, I think, for Kari Lake. Yes, it's a penalty. It's a sanction. It's $2,000, but that sanction will be paid and should be resolved. The bigger news is that this is now opened up. It's going back down to the Superior Court. And so we get to see what the Superior Court does with this issue about signature verifications, which we will, of course, continue to follow and see what they do with this and where this goes. Of course, thank you for subscribing and joining us as we cover it. So that's the Kari Lake update. And we're glad to see that one is moving along. That was one of those that I was checking on for a long time. Is anything happening in this case? Have there been any filings? Haven't seen much of anything. So we move on. We're sticking with some state level issues. And we have another good one. Kim Gardner, prosecutor from Missouri, who got a lot of that Soros money, is now resigning. And we've covered her previously here. You remember when she went hog wild over the McCloskeys. They were out there in their property on their front porch with their firearms protecting their home during the summer of love, when there were buildings and riots taking place all over the country with very little consequence. But the McCloskeys are happy because Kim Gardner is resigning. She submitted her letter on Twitter, and this comes after a pretty brutal hearing where the judge was holding her basically in indirect contempt, saying that he was going to be appointing a special prosecutor to go and investigate her. And she responded to this hearing saying, "I'm not going anywhere. You're going to have to come after me." And if you missed this, it was a lot of fun. Let's see what this judge concluded.
You ready? All right. The Circuit Attorney, Kim Gardner, was served with a notice and order to show cause directing her or a designated Assistant Circuit Attorney to appear before this court on April 27, 2023, to show cause why she should not be held in contempt based on an alleged willful failure to appear in Division 22 on April 10th and April 24th. Ms. Gardner did not appear. Assistant Circuit Attorney Mr. Huck appeared on her behalf, and Assistant Attorney Mr. Chris Deslitz appeared. The question before the court is whether Ms. Gardner and Ms. Deslitz's failure to appear on April 10th and April 24th amount to disdain and disrespect for the court. The Circuit Attorney's office appears to be a rudderless ship of chaos.
Beautiful.
Ms. Gardner is the Circuit Attorney, and it is her duty to manage the caseload of each staff member. Mr. Deslitz has approximately 104 felony cases. Any prudent practitioner would expect such a caseload to create countless irreconcilable conflicts. It does not appear she has made any reasonable efforts to prevent the resulting chaos. It appears that Ms. Gardner has complete indifference and a conscious disregard for the judicial process. There is sufficient evidence of disdain and disrespect for the judicial process to determine that both Ms. Gardner and Mr. Deslitz's conduct support a finding of indirect criminal contempt. Furthermore, an attorney's violation of a court's order constitutes an intentional disobedience and shows a clear intent to disregard the power and authority of the judicial system process. If a court allows such disobedience to continue, then its orders will become ineffective, thereby undermining the judicial system.
It's true.
The court finds that there is the requisite conduct and intent which could support a finding of intentional disregard for the judicial process. Ms. Gardner has counsel. Mr. Deslitz has the right to retain counsel. Both will be afforded their due process rights to discovery and to prepare a defense. The procedure for indirect...
So he'll go into the rest of it, but pretty brutal assessment from the judge, and Kim Gardner was not happy about that. And so rather than standing around and fighting like she said she was going to do, no, she decided to resign. Been a long time coming. You see, she submitted this on Twitter. May 4th, 2023, coming from the circuit attorney out of St. Louis, Kimberly Gardner says the following, copying the governor, Mike Parsons. My fellow St. Louisians, I want to start by saying it's been an honor of a lifetime to serve St. Louis, a community that's been resilient and deeply committed to finding solutions to making life better for everyone. And during my time as a prosecutor here, I've tried to embody those values. I believe that's why voters elected me twice. Unfortunately, here we go. Since the time I took office as the first black female prosecutor of the state, people outside the city have targeted me to advance their goals, have also targeted the fundamental rights of the city's voters. For example, the Missouri state legislature began hearings on a bill that appears to permanently remove the right of every St. Louis voter to elect their lawyers, their attorney, the only remaining elected position in the city. Instead, the bill gives the governor the power to appoint. It's hard to think of a more direct or brutal assault on our democracy, one that mirrors the attacks in Jackson, Mississippi, and throughout Florida. What does this have to do with your terrible performance and not showing up to court? Nothing. It is not the first time since the legislature had proposed bills to take away our city's power. That has happened in nearly every legislative session since I took office. It's also clear to me that as long as I remain in the office, it will not be the last. St. Louis is already one of the few jurisdictions in Missouri that does not elect its circuit judges. The governor has wielded this power. That makes the position of the elected prosecutor particularly sacred. So why aren't you running again then? An elected prosecutor is our city's sole opportunity. The proposed bill strips it away. If I can stop that from happening, I will. Even if that necessitates my considering leaving the office to which you have elected me. So she's going to leave now to go fight bigger causes. The letter continues. She says, the most recent bill, I'm still waiting to see if she's going to explain her terrible office. The most recent bill is part of a coordinated, long-standing strategy to undermine me and my efforts to make St. Louis safer and fairer. Since day one of my tenure as circuit attorney, I have experienced attacks on my reforms, on my judgment, on my integrity, on my prosecutorial discretion, on my responsibility to direct the limited resources of this office and more. Well, you've been doing a terrible job at all of those things. That's what the position entails. Don't run for office if you don't want to get criticized for your job. You are a policy person. People are questioning your policies as well as your judgment that is behind the policies and your integrity and your discretion. All of these are fair game. In fact, being a prosecutor is about judgment and integrity. It's supposed to be. That's what they teach us in law school. In the real world, it's a different story. Some of these attacks seem designed to stop the office, she says, from functioning. Yeah, so it's everybody else's fault at the expense of public safety, right? We have experienced an onslaught of record requests that no office in this country could reasonably fulfill. Oh, there's too much paperwork. Oh, along with attacks on our hardworking line attorneys designed to demoralize these public servants. There is no sign that the onslaught would stop for as long as I am in the office. I honestly can't take it with these people. All right, look, I used to run a law firm here, and I sort of know the difficulties of running a team and building a team and delivering legal services and all of this. It's a lot more difficult when you are not a part of the government, because the government has endless money and they have endless benefits and they just can hire whomever they want. And you should see how much waste is in these giant bureaucracies and really what goes on here. And so for her to sort of turn around and just say, poor us, woe is me, because I'm a government prosecutor that has the entire arm of the government at my back. It's too hard. We have too many record requests. These defense attorneys, the people who are questioning our decisions, it's too hard for us and we're under attack. Give me a break. Talk about a defendant who has no money, no resources, cobbles together some funds to go hire a defense attorney who's also on his own as a solopreneur, trying to juggle a bunch of different things. And they send in a couple record requests, and so she has a meltdown over it. Give me a break. She says, I can absorb those attacks, and I have. But I can neither enable nor allow the outright disenfranchisement of the people of the city of St. Louis, nor can I allow these outsiders to effectively shut down our important work. If not for these two things, I could continue to fight tirelessly to maintain the job you selected me to serve, right? So the reason her office is so terrible is because of everybody else. She's under attack and there's nothing she can do about it. But under my leadership and with your support, this office has made tremendous strides in redefining public safety. We have established innovative prosecutor-led diversion programs and significantly reduced police misconduct and created pathways to overturn wrongful convictions and won justice for victims. And we've expanded public health intervention and so many other things. But I cannot be the final circuit attorney to ever be elected in St. Louis. You must be able to have a voice, and we must be able to have our office continue. I will forever remain a tireless advocate for all of those who call our city home. Public safety is important in states where poverty and disinvestment exist. There is a coordinated intent on taking away the rights we hold dear. If we allow this to succeed, we'll never get our rights back. The most powerful weapon I have to fight back is your voices, and to fight for your voices and your rights is, here it is, to step back. I took this job to serve St. Louis. That's still my North Star. And so it is with a heavy heart, but steadfast resolve that I am resigning my position as your attorney effective June 1st. Not soon enough. Respectfully, Kim Gardner. Totally ridiculous statement. Just a big, it's not my fault, it's everybody else's fault. Our office is overwhelmed with paperwork. We don't have enough resources. We can't handle this job. And these attorneys' offices are some of the most well-funded institutions in the whole government. What a joke. All right, well, goodbye and good riddance. Here is another celebratory adios, cheers from the McCloskeys. Here's what they said about it.
Well, here's to the resignation of Kim Gardner, the city of St. Louis.
Let's blow that up again.
Well, here's to the resignation of Kim Gardner, the city of St. Louis will be much safer. There is justice, there is a God, and justice and God have prevailed. Thank you very much.
Cheers! Cheers to the McCloskeys. Cheers to the McCloskeys, and adios to Kim Gardner. So, good news. Kim Gardner resigns, and St. Louis is all the better for it. All right, and so let's continue on. We've got a lot more to get to, and we're just getting warmed up over here. Police sue for the Manifesto. Law enforcement investigating in Nashville have told us that we were going to be getting our hands on this at some point. But that doesn't seem like it's happening. The question is why? And a lot of police have the similar concerns because we know there was a bunch of stuff seized in the investigation. Here is one snippet of some of the inventory. We see the firearms. We saw 7 journals were picked up under the bed. We saw there was another journal in a box labeled Audrey's stuff in a basement under the stairs. There were 11 home videos seized. We had a note called New Song. There was a notepad with a bunch of passwords on it. 2 more journals. There was a note on here that people leave when they end their lives. Passwords on other sticky notes. 2 Honda keys. Lots of stuff. That was just on page 1. On page 2, we saw a lot of other things. We saw laptops, Samsung tablets, videos, different phones, all sorts of other writings. The list goes on and on and on. But why are we not seeing it? Why do they continue to hide evidence from us? We still have questions about the Las Vegas incident and so on. We don't know what is out there. And the police now want answers. This came over from the National Police Association, part of a press release. They tell us that they file a lawsuit to obtain the manifesto and other records. Coming out of Indianapolis, the NPA, also known as the National Police Association, has filed a Freedom of Information Act lawsuit in conjunction with a Tennessee private investigator called Clada Renee Brewer. I have the lawsuit we'll take a look at. Against the government of Nashville and Davidson County for refusal to act on a request for records. They want everything, all the writings, manifesto, everything relating to the March 27th incident that took place in Nashville, Tennessee. Audrey Hale was there. 6 dead, 3 children, 3 adults. So let's take a look at what is happening here in this claim. You see, the lawsuit filed April 28th out of the Chancery Court, Davidson County, Tennessee. The case is Brewer versus the Metro Government of Nashville. They say that the police agency files this complaint to receive prompt access to inspect and copy certain records maintained by Nashville. The Metro Government has failed and refused to produce these records, and we want them. Who is filing this? They tell us a little bit about Cleda Renee Brewer. Miss Brewer is a citizen of Tennessee. She is in conjunction with the National Police Association working together. So she's a citizen there. She's got standing. She's going to help file the suit. Defendant is the government. It's a governmental entity. The law says they've got to reply and comply with public records requests. The act says that all state, county, and municipal records shall, at all times during business hours, be open for personal inspection. But the Metro government is not allowing that. The government is the creator and the custodian of the records from the incident, but the PD has not yet responded to the plaintiff's request. But instead, on April 12th, it denied a substantively identical request from somebody called Tonda Johnson. We have an exhibit of that as well. In the exhibits, Brewer and the police, they have requested records relating to the event that occurred in Nashville on March 27th. On that date, Hale unlawfully entered the school heavily armed and caused the tragedy. Officers of the Metro Police Department quickly responded to the incident. The officers entered, located Hale, and eliminated her. Since that time, the actions of the Metro PD have been correctly characterized as commendable and heroic. No one has suggested that the officers engaged in any criminal activity at all. Says that there is no criminal prosecution concerning this incident. And despite the extensive media coverage, including interviews of public officials, no one has suggested that there will be any criminal prosecution at all. And so the government's reason for not allowing the disclosure of these public records is not applicable. It's not an open case. Because there is no criminal prosecution, it doesn't apply. Rather, this case is controlled by other laws. And in a similar case, they decided that those cases were also closed. They tell us that here, the government has not identified anyone who might be subjected to any prosecution. So the government is saying, we can't give you these records. We might charge somebody. And they're saying, well, who? Who is it going to be? Who are you going to charge? We don't think the police should be charged. And the individual is dead. They can't even identify any class of persons who might be subject. And the government hasn't even identified any crime or any class of crimes that might be charged. No indications from the government, even whether an agency is investigating it or whether they might bring charges at all. And so since the incident, law enforcement officials have made numerous comments to the media concerning some of these records that we've requested, but these comments are inconsistent with there being any prosecution. And so therefore, court, we ask that the court schedule a hearing with the government to appear and show cause and explain why we shouldn't be granted these records. The law says we should go in and inspect them. You're not allowing us to do that. And if they can't come up with a good reason, make them promptly produce the documents. We want you to set a date and a hearing within 5 days, issue a new order, ordering the government to produce the documents as quickly as possible. Tell them they're not exempt from these other laws. And we also want costs for this as well. Respectfully submitted, your friend, Douglas R. Pierce, out of Nashville, Tennessee. So that got submitted, and there are various exhibits here explaining some of the stuff that they want. This was a part of their Freedom of Information Act request. They're telling us the incident. They want all writings, including the manifesto of Audrey Hale. They want all records describing the writings, all records depicting the analysis of the writings, all records of communication between the PD, the Director of Community Safety, or records from everything. Text, communications, and so on. All of it they want, and they filed a lawsuit to get it. Now, we'll see what the circuit court, the Chancery Court for Davidson County, Tennessee does, but we're all looking forward to seeing what those documents entail, and there's probably a reason why they don't want us to see them. Now, we continue on moving quickly because we've got a lot to get to still. We have CIA Director Michael Morrell openly sent an email saying that they wanted to create a talking point for Joe Biden before the debates in 2020. We've already talked about this story because Morrell was interviewed, and he said in his interview that this was part of his plan. He didn't want Donald Trump to win, and he thought that maybe this was in fact Russian information, and it would be very useful for 51 so-called intelligence experts to come up with a talking point that would be useful to the Biden presidency. And they created one. And we see it here in an email format. The email came out from John Brennan, October 19th, 2020. Isn't that interesting? Was there anything else important going on? October 20th, 2020. Oh yeah, the election was like in 2 weeks. Subject is regarding a letter to sign, responding back to Michael Morrell. Both of these people signed the letter. We've talked about this letter a lot here. And here is what the request looked like. Former CIA Director Michael Morrell, who is responsible for organizing this list, sent a letter to John Brennan, 9:29 a.m. Hey, John, CIA buddy, can I add your name to this list? Says, I will be adding Leon, Sue Gordon, Jay Johnson, George, Lisa Monaco, who didn't ultimately sign this, and Mike Rogers from DIR NSA today. Says we're also working on Dan Coates, Mike Rogers, and Tom Bossert, and a lot of other IC career folk. Trying to give the campaign, particularly during the debate on Thursday, this is the debate between Trump and Biden. When Biden got out there and he said, I don't know what he's talking about, my son's laptop. There are 51 intelligence experts who signed this thing and said it's legitimate. Michael Morrell says, trying to give the campaign, the Biden campaign, particularly during the debate on Thursday, a talking point to push back on Trump on this issue. To push back on Trump on this issue. Trying to give the campaign a talking point. Creating this letter out of thin air. Trying to give the campaign a talking point on Thursday to push back on Trump on this issue. Not anything about this is really true. You know, this is really a threat. This is a big concern for the United States. This really is Russian misinformation. We really have to correct the record. No, none of that. All they wanted was a stupid talking point to push back on Trump on. And they got it. And they used it. And these are the people who are supposed to be honest and open with us in the interest of American democracy, to make sure that the public is protected and safe, to stop this misinformation from going out there. These people all knew or should have known, in my opinion, that the Hunter Biden laptop story was legitimate and authentic because we were able to piece it together here. There was more evidence showing that it was real than not. And we were proven to be right. And they knew it too. They had possession of the laptop as late as 2019 at the FBI. So in 2020, they could have vetted it. They could have known about it. We were able to take a look at email headers, and people were cross-referencing the emails with news articles that showed, yeah, Hunter Biden was with Daddy over there at the time. It all matched. It looked authentic. So this was to create disinformation, misinformation, create talking points, and these so-called public servants, these people who are out there supposed to be protecting us and making sure that our information is good and accurate, they were openly getting involved in talking point creation for the president, for the, not yet, for the Biden administration. And they wanted roles in his administration. Michael Morrow wanted to go back to the CIA, or he wanted some position. So they were all playing and providing favors to the incoming administration. Some of the most disgusting anti-American treasonous behavior you've ever seen. They are doing the opposite of what they are sworn to do, which is to protect and uphold the Constitution. They are interfering with it directly, and it's disgusting. So that is what is happening, right, in our intelligence agency. And there's more coming out from our intelligence agencies. The Biden whistleblower is still circulating around out there. We're waiting to get some new documents. But the question is, what does the document show? And is this whistleblower legitimate? James Comer over on the Oversight Committee says he definitely is. We know the letter has gone out from James Comer and Chuck Grassley over to the FBI, demanding they get their hands on these whistleblower documents that implicate the Biden family. And Comer was on explaining exactly how this works and why this is such a big problem, if this video will load. If not, I have a different way to get it, but let's see if it loads. Okay, let's try a different video. Now we're going over to Chuck Grassley over on YouTube. And here is what Chuck Grassley had to say about it.
In the past several years, I have come to this Senate chamber to discuss my constitutional oversight of the Justice Department and the FBI. In many of those floor speeches, I've discussed legally protected and unclassified whistleblower disclosures that were made to my office relating to the Hunter Biden criminal investigation. These disclosures were made public in the interest of transparency and accountability, because the public's business should be public, and we should know, as senators or congressmen and congresswomen, whether the executive branch of government is faithfully executing the laws as the Constitution requires. Those disclosures that I've made have a very common theme. The Justice Department and FBI have allowed political infection to take root within each agency's decision-making process. Such an infection is an existential threat to any government agency, but to a law enforcement agency that can interfere with our constitutional rights, such an infection is catastrophic. After Crossfire Hurricane,
it is an infection,
which was the definition of a political investigation.
Political
The
infestations.
whistleblower disclosures demanded congressional attention more than ever. So
that's Chuck Grassley in the Senate, and he's really focused and fired up on this issue. He's been focused on it for a long time, and he's joined by James Comer, who is also explaining what they are after here.
Tell us, Congressman Comer.
Well, Senator Grassley and I have both reviewed that disclosure. We find it very credible. We're very concerned. We have a lot of questions as to whether or not the FBI even looked into this. We know from your previous reporting that you've already stated on the show that they turned a blind eye to anything pertaining to Joe Biden, and they just assume the worst when they look into anything that pertains to former President Trump. So we're very concerned about this, and I'll tell you why, Sean, because as you know, I possess bank records from the Biden family now, and there's a consistent pattern of the Bidens using LLCs to receive payments from our adversaries around the world, including the Chinese Communist Party and many other countries, that go into various LLCs, and then they transfer them around in a type of money laundering scheme and then transfer the money back to different Biden family members. We've identified 9 Biden family members that have received these type of payments from adversarial countries around the world. Now, the question is, what are they doing to receive these payments? Then we get this very credible whistleblower come forward. And we have, again, reviewed this specific disclosure. So now we're requesting that disclosure from the FBI, and we want to know exactly what they've done to verify whether or not this allegation is true.
Yeah, there's a big question about that, because we know that the document that they were requesting was a memorialization of an interview, and apparently the concept is a whistleblower came to the FBI or to the DOJ and said, hey, I've got some pretty bad evidence that implicates the Biden family, and I want to communicate it to you. And they said, okay, let's have a sit down. Part of the sit down is you have the conversation, then you memorialize it in a document. That document allegedly is in a drawer somewhere at the FBI or DOJ's office. And Comer's saying, have you guys did you do anything with it? Like, the whistleblower came and made this report to you. Did you take action with it, or did you just dump it in the shredder because you didn't want to address it?
I think it would be very difficult to destroy. It's my understanding that it is submitted within their database, and it's very difficult to take that out and destroy it, because I had that same question.
Have you ever heard of bleach pit?
Now,
have you ever heard of bleach pit?
We're seeing it all with respect to the FBI, unfortunately, but we're very confident that this does exist. We're very confident in the whistleblower. And look, this fits a pattern of behavior that the Bidens have done, because we've already identified millions of dollars into 9 different Biden family members, and we don't have any idea what they did to receive that money. There are no businesses. That's what the Biden attorneys and their friends in the media have said. Well, these were legitimate investments into different Biden business interests. There are no business interests, Sean. The business was the Bidens creating different LLCs, trying to hide who the source of the transfer was, and then deceive the IRS, and then goes back into the Bidens' back pockets. So what did they do to receive this money? And again, we take our whistleblowers very seriously. As you know, there have been 2 very credible whistleblowers come forward in the last 2 weeks. We're doing everything we can to protect these whistleblowers and to try to encourage more whistleblowers to come forward. But we have credible evidence, and we want to know exactly what the FBI did to verify this.
You talk about a foreign national.
Because they didn't do anything. They've had evidence of this family's nefariousness for a long time. They've had the laptop. They knew about Hunter Biden's gun crimes. They've known and followed this around for a while. Joe Biden's been in the government forever.
I'm not at liberty to say right now. Again, we're waiting for the FBI to comply with our subpoena.
I'm teasing.
You'll be the first to know, Sean.
No, to be honest, Congressman, you're talking about a vice president being bribed, and he's now the president of this country. You know, a balloon flies over our country and nothing happens. A drone is taken out of the sky and nothing happens. Is it because the president is compromised? I worry about that. Am I wrong to worry about that?
No, you're exactly right. That's why we're investigating Joe Biden. The media wants to talk about Hunter Biden. Look, we've already disclosed that there are 9 Biden family members. It isn't just about the president's son. It isn't just about the president's brother. It's about the president's entire family. But let's be real. I mean, does anyone believe that they're getting this money just as coincidence? I mean, there are countless transactions from many countries that no one else would ever do business with. Even some of the biggest companies in America that have a huge international footprint don't even do business in some of these countries. What are they doing to receive this money? This fits a pattern with everything that our whistleblower, our very credible whistleblower, has alleged that Joe Biden did when he was vice president. That's why we want to know what the FBI has done to verify this claim. We know they have the claim. We want to know what they've done to verify the claim.
Somebody filed a complaint. The FBI is just sitting on it. So the whistleblower then seems like they went over to Congress and told Congress they are just not doing anything with my complaint. Please go and investigate. So Congress is doing that. Byron Donalds was on, and he explained his reaction to this.
My initial thoughts are, I'm simply not surprised. Laura, we've been going at this investigation in the Oversight Committee for months now. A couple of weeks ago, I was at the Treasury Department reviewing some of the financial documents associated with things that Hunter Biden and Jim Biden have been involved in. And at any point throughout this entire situation, you could never get anybody who just uses basic common sense to actually believe that Joe Biden had no idea what his brother and his son was doing.
Right.
Now the whistleblower has come forward. Apparently FBI has documented this and has looked into this. And the American people need to know, they need to see if their president is compromised by foreign nations because he and his family wanted to make money off of his political power that he has amassed over 50 years in government.
It is troubling indeed. Now, of course, we've got questions for the White House. Are they going to speak about any of this at all? Not really. They're not really doing much of anything. In fact, something we talk a lot about on our members-only morning streams is that the presidential schedule is basically non-existent. This is what it looked like today. He had a meeting with his Investing in America cabinet. Oh, that's nice. So they had one meeting today. He got his briefing. He had a meeting today at 11:45. He also yesterday didn't do really anything. He got a presidential daily briefing. Oh, that's nice. What did he do on Wednesday? He had a dinner. Okay. So they don't really do much other than have lunch and have dinners now. The president and the vice president, they had lunch. And so all of these questions come in. We want to know, are they going to address any of it? Or are they just going to say, we've got nothing for you? You can pretty much guess where it goes. This is how John Kirby responded in the White House.
John, I've got a question about the House Oversight Committee subpoena that was issued yesterday. It's seeking an FBI document from 2020 that, quote, describes an alleged criminal scheme involving then Vice President Biden and a foreign national relating to the exchange of money for policy decisions. What's the White House's response to this serious corruption allegation?
I'm going to have to refer you to the Justice Department on that. I have nothing for you on that today.
No, do you know what this is, what country this pertains to, or what policy decision?
I have nothing for you, sir. I'm going to have to refer you to the Justice Department.
Nothing on that because they don't want to talk about it. So the Biden crime family continues to march forward, but Congress is now demanding some answers, and we'll see what the FBI says in response. Now, Congress is not just going after the Biden family. The House Oversight Committee is now going after the DOJ, saying, hey, we tried to ask nicely and play in a compassionate manner with you, but things are going to have to escalate since you're not cooperating. The House announces a new letter demanding cooperation. Otherwise, they will go through a compulsory process and issue some subpoenas. They put this out May 4th. Comer says that the U.S. Attorney for the District of Columbia must testify about failure to prosecute the majority of the crimes. Otherwise, there will be a subpoena to compel your testimony. James Comer is reiterating his request over to the DOJ. In particular, sent a letter about U.S. Attorney Matthew Graves. And we've heard a lot about this guy in the January 6th prosecutions. They say during a recent committee hearing on oversight, a central theme was Mr. Graves' pattern of not prosecuting crimes in D.C. because they'd rather focus on the J6ers. The District of Columbia is a federal district under the exclusive jurisdiction of Congress. Unlike other attorneys in the DOJ, Graves is the only U.S. attorney who serves both the local and the federal prosecutor of his area of responsibility. Mr. Graves' unique role makes his testimony necessary to conduct meaningful oversight, especially regarding crime. So we'll take a look at the letter drafted here from Congress and the House of Representatives, the Committee on Oversight and Accountability, drafted by James Comer from Kentucky, the chairman. Letter sent over to the Honorable Merrick Garland, Attorney General of the U.S. DOJ. Comer says, all right, Mayor, the Committee on Oversight is conducting an oversight hearing on May 16th coming up to include officials responsible for the affairs of the D.C. area. We've invited several people. One is Mayor Muriel Bowser, who we would love to hear from. I've got a lot of questions for her about J6. And the U.S. Attorney for the District of Columbia, that's Matthew Graves. Good, got a lot of J6 questions for him too. Mayor Bowser has accepted the invitation. Woo! So mark your calendars, my friends, for May 16th. the Department of Justice has informed the committee the DOJ has refused to allow Mr. Graves to testify. So Congress is unhappy about this. They say, well, the Department of Justice excuse is an internal policy that generally prohibits U.S. attorneys from testifying before Congress. But that excuse is unpersuasive, says Comer. It's also inconsistent with past precedent. Indeed, the DOJ has made a U.S. attorney available to testify at public hearings as recently as last Congress in 2022. Furthermore, Matthew Graves' testimony is necessary to enable the committee to perform oversight of city affairs of the D.C. area over which we've got jurisdiction. So, Comer says, I therefore reiterate my request for the appearance of Matthew Graves from the DOJ and demand that the DOJ follow its own policies and cease obstructing his appearance on May 16th. He says the District of Columbia is a federal district under the exclusive jurisdictions of Congress. Unlike other attorneys, Mr. Graves is the only attorney who serves the local and federal prosecutor for this area. His unique role makes his testimony necessary for oversight of the city, especially issues regarding crime. The DOJ recognizes the attorney's office has a unique role in this city. And in fact, DOJ had Graves testify at a DC Council Committee hearing previously in December 21. Comer continues. He says Mr. Graves and the DOJ and his office's decisions are contributing to rising crime in the city. At the oversight hearing in March, DC Council members in part blamed the U.S. Attorney's Office for rising crime. DC's blaming the feds. Graves' office is declining to prosecute violent crimes. As crime continues to spike throughout the district, Graves must be responsible to answer questions. In addition to contradicting past practice and obstructing the legitimate prerogatives of Congress, DOJ's position is also inconsistent with their own manual. They're violating their own policy by refusing to allow him to testify. And so Comer says, we urge the DOJ to reconsider its position, make Graves available to testify. Please respond to this letter very soon and let us know. If you continue to obstruct congressional oversight in this matter, we, Congress, will be forced to consider the use of compulsory process on your butts. For any question, please consider the committee and contact our committee and give us a phone call. Don't forget, just like Liz Cheney liked to say in her illegally constituted committee, the Committee on Oversight has broad authority to investigate any matter at any time under House Rule 10. Thank you for your attention to this matter. Sincerely, your friend, James Comer. Oversight Committee and Accountability. Copied, Jamie Raskin. So, a nice letter going over there. We would love to hear from both Muriel Bowser and Matthew Graves. Now, what's curious about this is they don't mention January 6th at all. And it sounds like this is only going to be about crime in D.C. And part of the reason for that is they probably want to keep this separated, right? There's probably some jurisdictional overlap. They can't openly investigate J6 stuff because that was within the purview of the J6 Select Committee. So they're going to investigate crime in D.C. and they're going to, I would presume, ask questions about why are all of the efforts being focused on January 6th rather than the crimes in D.C. Maybe Matthew Graves can answer the question for us. And so we'll, of course, see what the DOJ says in response to that and whether or not Matthew Graves ultimately appears to testify. But Congress is taking action, and we're excited to see where it goes. But all right, my friends. Wow. Okay, so we covered a lot of ground today. We got through it pretty quickly. We got Biden crimes, family. We had that ordeal. We talked about the House failing to prosecute and Congress demanding answers. We talked about Michael Morell, former CIA director, who is highly involved in spreading and creating misinformation. The police sue over the manifesto. We covered that one. Kim Gardner resigned and the McCloskeys are celebrating. Cheers to the resignation. We hit the Kari Lake order and the remand, which means her case is now going to be moving forward. And we also covered Trump and his filing to remove his case from the state court up into the federal court, and Alvin Bragg will respond to that one as well. But that is it for us on the day, my friends. Woo! We covered a lot of ground. It's a beautiful Friday. Those are some fresh stories. And now let's see what you have to say about this. We are going over to our members only watchingthewatchers.locals.com after party here in a short bit. But I want to say thank you to our amazing supporters who sent in the super chats over on YouTube. And let's get those queued up. And thank you for everybody who is joining us early. We're joining us early today. It's Friday, my friends. And who is here? We had a couple come in, and thank you, everybody, for sending these in. First one in the house came in from Chris Wolney. He says, beat Navy, the judge must be a West Point grad. I saw that too. You know, sometimes judges have some personality, which is a nice thing, actually, sometimes. But that's a big one. Like, was the game that weekend or something? Or is that just like a general thing? It's like pretty right there in your face, right? Good to see you, Chris. Thanks for saying hello and for the super chat. I also noticed that. I'm like, damn. What if a defendant comes in and he's in the Navy or he's on the team? You're like, oh, crap, I'm totally screwed. Your Honor, my defendant's the quarterback. Oh, perfect. Well, he's going to prison. When's the game? When's the next game? Prison. Arrest him. We had another one from Carl Borchers. He says, isn't writing a false intel letter to affect an election with the goal of eliminating Trump considered sedition? How is this not illegal? I don't know. Carl Borchers. I don't know. I mean, they charged Mackey, the illegal memer, for illegally meming stuff. I guess honestly, the question, the issue here is that they've got plausible deniability. All they do is just say, no, we thought it was Russia. And look, all of these other experts thought it was Russia. And since they all have, strength in numbers, and everybody in the intelligence agency and the DOJ and the Democratic Party and the current administration, since they're all like, it served all of them, nobody cares. Nobody's going to look into it. It's like, well, we wrote a letter. It worked. We wrote the letter. It worked. Nobody's going to do anything about it. Tara Rayner says, Rob, see Millie Weaver, October 2020 report about Jan 21. All right, Tara, I'll take a look at that. Thank you for sending that in. Also says, tried 7 times to post a detailed chat, but was denied by YouTube. I wonder what you were trying to chat there. Did YouTube censor you? Wasn't on my end. Blame the tubes. Thank you, Tara. I appreciate you sending those chats in. And Patrick Parker also says, it is illegal, but if you have an entire DOJ in your corner, you can literally get away with murder. It says Carol. It is illegal, but if you have the entire DOJ in your corner, you can literally get away with murder. And that is a scary thought, isn't it? Thank you, Patrick, for sending that one in. Yes, indeed. It's good to see everybody on the YouTubes. Who's over on Rumble? I see Vientikis is modding up over there. We got Jacob Indoctrination. Bubbles Gaming is over there. We got Discoursey. What's up, Discoursey? We got Nug Monster. Says Re is our battle cry. Doxy Lovers over there. La Azteca. Slightly salty. Good to see everybody in the Rumble chat. Let's say hello to Twitter. And then, of course, we are going over to our members only after party here in a short minute. And let's see. John McGarvey gifted 10 memberships. Speaking of going over to our memberships, John McGarvey just brought in, thank you, John, for doing that. TJ, 2B Flair is joining us. Rebecca, Lexi, welcome, Lexi. We got Messi Chavez is here. What's up, Messi? Leo Dewa, we got Tatted Cat, Nikki Perez, Donetta is in the house, and Catherine W., all courtesy of John McGarvey. So welcome, everybody. And if you're just joining us on YouTube, don't forget to grab the Telegram chat. It's in the community tab. Just scroll down a little bit. You'll see it posted there because that's where we are going. And Vanessa Thring is also a supporter. Welcome, Vanessa. We're going to see you here in a minute, too, hopefully, on Telegram. And then, and then members, Yeah, and then members, we're going to be back here tomorrow morning to do a members only stream, and then we might do something later. We're probably not going to come back later for there's not going to be, this is the show for the day. But members, there's always a little extra member stuff, so we'll see. Now, Vientikis is also sharing this. Voice of the People also invited Barb B. Thank you, Voice. Voice of the People invited Barb B, Frank Barron, Frezio, Angelia Green, and Trevor Leathers over to our membership community on YouTube, and we're super grateful for that. And oh my goodness, Dolphin Fan sent in a very nice super chat that just came in. Thank you, Dolphin Fan, for sending that in. Very, very nice of you. Says, have a blessed and fun weekend, everyone. Rob, thanks for your amazing work. Well, thank you, Dolphin Fan. Dolphin, you're extremely generous. I appreciate you bringing everybody in, constantly contributing to our growing membership. Thank you for doing that. And thanks for being here every day and joining us in the chats. Extremely generous. I appreciate it. But okay, my friends, let's take a look at what's over on Twitter, and then we'll wrap it up on the day. We got 3 people are watching. Whoo! We have this one from V says, there isn't a doubt in my mind that the juries aren't being fortified. Well, they had those meetings. I was wondering if they were meeting with the FBI. TJ says, good point on the 51 intel people and the election. If a minor memer lacking intent can be convicted, why not 51 massively influentials with proven intent? Yeah, this is another. Yeah, meanwhile, Douglas Mackey was convicted. But this is not anything. It's disgusting. It makes your blood just boil instantly. Here, thanks for pointing out the obvious in a clear and easy way to understand. You're welcome. I love pointing out the obvious. I'm very good at that, especially the really obvious things. I usually can get those sometimes, although sometimes not also. So I appreciate the comment over there on Twitter. And of course, that is going to be it for us on the day, my friends. Thank you for joining us on this early show. We appreciate you being here. Of course, it's going to be a busy, busy weekend. We covered a lot of ground today, but we will be back tomorrow for our members only morning stream, see what else the weekend has in store for us. And this came out, watchingthewatchers.locals.com. Come check us out. We're going to be going over there for our after party. And YouTube members, definitely grab the private Telegram chat as well. Tara's message says, Millie Weaver reported on leaked Zoom calls of lefty organizations plotting a takeover of the Capitol. She reported it to the FBI and nothing. Super chat on this failed. Thank you, Tara. So that's a reference over to Millie Weaver and her reporting on a Zoom call, which I don't know that I'll look into that. I'm not sure that the name sounds familiar and the stories sound familiar. We had all the John Sullivan stuff. Remember John Sullivan was there and he was selling his footage to CNN for like $75,000 and all this stuff. There was a lot of weird things happening there. And this is a point that we've asked about a lot here. I want to know about the charging decisions from the DOJ, not only just the people who were charged, like we see everybody who got charged with a crime, but I want to see everybody who was investigated, which is a much bigger circle, much bigger scope there. Who was also investigated but not prosecuted? And more importantly, what were those declination decisions based upon? What was the justification for that? Why did the Proud Boys get charged? Why did the Oath Keepers get charged, but not Ray Epps? There should be a file for Ray Epps in the DOJ's office. There certainly was an FBI file for him. Why were they declined? And not just Ray Epps, but everybody else, right? All of the other, was Antifa even considered in this? Of the 1,000+ people charged, how many of those were from Antifa? Are you telling me there was not a single Antifa person there? What did the numbers look like? You know, I don't know. So that, my friends, is it for us on the day. It's going to be a beautiful weekend, and so make sure you get your field of green so you're properly energized and nutrified and fortified. So whatever activity you're doing is amazing. And you can do that over at fieldofgreens.com, where you can save 15% with code Robert. And the vegetables want to be eaten, and you'll be bursting with green energy. Just look at this. It's just out of control, bursting all over the place with the good energy, the good kind. And also, my friends, if you want to create a mind map and do some mind mapping of your own, like we do here, check out a free account at spotlightlawyer.com/mindmap. And if you're having problems with any of these links, make sure you put the www out there in front first, just so that you can get over there. spotlightlawyer.com/mindmap. And we had a super chat come in from our friend Fred Petamonte. Fred's in the house. He says, midday show. Next time you call me ASAP. That's from Johnny. Johnny's upset. Sorry, Johnny. Johnny likes to be notified about everything, but we just jumped on here. Apologies to Johnny. Good to see you, Fred. Glad that you made it. And Michelle Martin says, okay, see you later. Got to run. And who else is here? Let's say thank you to the mods and our meme smiths out there. The Antikiss Prime in the house. We got K Bean modding down the fort for us, along with Just Cause, our friend Playin Hooky, Ronnie Cole, Zulu Geomancy. We've got Zach Nichols in the house, our friend John Allen, Janek 909. We've got Dog Digger. We've got Donut Mind Me, all modding down the fort, helping keep the train on the tracks, and we appreciate everybody. Thank you to Sleepy Dog Lee and our friend Geegum Geegum, our meme smiths extraordinaires, who help keep the show nice and beautified. We appreciate everybody for it. Now, we are done for the day, my friends. We are going over to watchingthewatchers.locals.com. If you're a YouTube member, grab the Telegram link and join the Telegram so you can join us as we do a little bit of a debrief here. But we are done for the day. We'll have a members-only session tomorrow morning to see what the news has in store for us. We'd love to have you join us. But if not, my friends, have yourselves a beautiful weekend. And hopefully you're doing something amazing. Getting outside, connecting with friends and family. I'm going to be going and seeing some puppies at the Gouveia household. Just came out. We talked about that on Locals. So we're going to be going and doing some puppies. They're tiny little puppies. Going to go check them out. And it's going to be a beautiful weekend, getting outside, getting some fresh air, some vitamin D, and some rest. Because next week, it's going to be busy. We're going to be wrapping up with the Trump trial. We'll see what else we have in store. And I hope to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend and a beautiful evening, my friends. And I'll see you right back here on the next one. Bye-bye.